Good afternoon, everyone. On behalf of the International Practice Section, I'd like to welcome you to this CLE event. Today, we are honored to have a panel from Spain. As some of you may know, our firm, Harris Sliwoski, by the way, I'm Fred Rocafort. I'm a member of the International Practice Section's Executive Committee and an attorney at Harris Sliwoski. And our firm, Harris Sliwoski, has a very close working relationship with Monereo Meyer Abogados, a law firm from Spain. In fact, some of our attorneys wear dual hats as attorneys at both firms. And today we are delighted to have three such attorneys join us for a very timely event. As some of you surely know, Spain has been one of the countries hit the hardest by COVID-19. At the same time, it was before the pandemic and continues to be an exciting investment destination. So on that note, we are going to be having this presentation on the topic of Spain after COVID-19, new regulations explained from a practical perspective. And joining us today from Spain are Nadja Vietz, Andrés Monereo, and Consuelo Álvarez. I will allow them to introduce themselves a little bit more fully, just to make sure that that I don't leave anything out. So on that note, Nadja, I turn it over to you. Thank you.
Thanks, Fred. Good afternoon to everybody, and good evening to us. It's really late here in Spain now, but I realized today when I was getting tired, and it's better than having jet lag. So we are streaming live from Spain right now. It's in the middle of the night, and I'm still glad you could join us. So this was supposed to be a roadshow to the US in close collaboration with our alliance firm, Harris Sliwoski, and but it couldn't be, as you all know, for the obvious reasons. We couldn't travel, so we decided to do this a virtual event. And thanks again for Harris Sliwoski to sponsor this, and thanks for the WSPA to invite us. This pretty much feels like a homecoming for me, because I actually lived and practiced in Seattle for 10 years, and I was secretary of the international section of the WSPA because I'm also licensed as an attorney in the US. So if there's anybody listening that knows me from before, good to virtually meet you again, and thanks again for joining us. The topic today will be Spain after COVID-19 and new regulations explained from a practical perspective. And we'll have 3 blocks in our presentation, and let me show you what the agenda is today. I will first be giving a brief overview of new and old legal issues US companies face when doing business in Spain, which is what basically our clients encounter when they come here to Spain, and which is what I briefly wanted to explain to you a little bit without going too much into detail. And then I will hand over to my partner, Andrés Monereo, who will talk about managing distribution channels in times of COVID-19, and particularly about commercial agents, agency law and the Spanish law, which is quite different from what you know in the US law. And we will then, at the end, close our presentation speaking about new regulations and restrictions for FDI in Spain, particularly new FDI restrictions. Foreign direct investments get restricted in the whole European Union, which might be interesting for you. And then Consuelo, my colleague here from Monereo Meyer, will speak about protecting your IP, and GDPR, also a hot topic still. And we will close the presentation giving you some information about anti-money laundering rules in Spain and Europe. So let me brief introduce ourselves. Monereo Meyer Abogados. It's a catchy title, the story of 30-year cross-border adventures. But it's true, we just celebrated our 30th anniversary last year. Our firm got founded in 1989, and we are more or less 30 lawyers and 3 offices. We're based in Madrid, Barcelona, and Palma. And most of our lawyers are fluent in several languages and licensed in at least 2 countries, because our core business has always been international law. Initially, mostly for German clients or German-speaking clients doing business here in Spain. But then when I joined the firm, since then we've been working a lot with US clients. And the history behind that, as I told you already, is that I used to work and live in Seattle, so I'm also a licensed Washington lawyer. We are a full-service law firm. We have 3 main practices, which is corporate, litigation, and real estate, and our sub-areas including antitrust, banking, finance, M&A, commercial employment, and insolvency. So really full-service, tax law also. And again, everything, all our work is cross-border business focused. So let me jump right into the first part of our webinar today. This is a speech I love to give because I'm not going to go into much detail. I just tell you about our daily business, our daily practice, and what we encounter when US clients or foreign clients come to us here in Spain and just don't understand how things are done, because there are some differences. And this is the theoretical part. We all know that there's the common law system in the United States versus civil law tradition in Europe. This is the theory behind, right? The civil law tradition means it's based on compendiums of rules, and we call them codes. And it's basically historically, it's 2 codes, the Roman code, the Justinian code, and the Napoleonic code. And most European countries have copied the Napoleon code. So when I first studied law in Germany, I pretty much learned the same civil code as I'm now applying here in Spain. The fundamental difference, and you probably all know that because we're speaking to attorneys, is that in Europe here, only codified law is binding for the court. So when we start working on a case, we open the code and look for the applicable statute, and not as you guys, you look for case law, which is in the end, I always say, in the end, you come to the same results. The arguing and the reasoning behind might be different. And there are, of course, little details in the practical application that I'd like to explain to you. Another big difference, of course, is the regulatory law. European law is way more protective, and so we have very strict regulatory law in data privacy, for instance, and food and energy law, and consumer and environmental laws. That is also the reason, one of the reasons why the famous or controversial transatlantic trade and investment partnership, the so-called TTIP, that was negotiated a couple of years ago to make international trade or US-European trade easier, it failed because both countries could just not find common standards. For the practitioner, again, as I said, it's not much different. And I get asked a lot about what system is more business-oriented. It's a difficult question because Spain seems very formalistic and less agile, and everything takes much longer than the US. But in the end, we have many business opportunities as well. And one big advantage here in Spain is that it is predictable because we work on codes, and there's less litigation, and there's no punitive damages in commercial contracts. So pros and cons in each system, of course. Let me first give you some numbers also before I start explaining some of those details, and numbers about business in Spain. And those were the numbers before COVID, of course. This is what we were telling people last year. The United States is a very important trade partner for Spain, and vice versa. You rank because it ranks first in investments in Spain with 16.4% of total investment, and second in investments from Spain with 15.5%. So really important business opportunities for both sides. Of course, we don't have any numbers right now to compare. Right now in the COVID pandemic crisis, I didn't find any of those numbers to compare. What I did find was a McKinsey report that just came out, and now in September, and speaking about recovery time and what we can expect for investments in Spain. And speaking about investment in Spain, it must be said that the spread of COVID-19 has touched every facet of Spanish society, of course, and has been matched by widespread economic disruption. So we were in complete lockdown for 2 weeks and lockdown for several weeks. And there's that McKinsey report divides into three groups of industries, and they say basically they were talking about recovery at the end of 2023. So the impact of COVID-19 will vary by sectors, and of course there's the sector that had the most drop in revenues, as more than 20% in revenues, which is the sectors that are still or have been a long time and are still restricted, which is accommodation, food service, transport, car, real estate, and tourism, of course. And then there's another group of industries where there's drops between 10 and 20%, which is construction, logistics, professional activities, financial, energy. And then there's a third group that hasn't been hit that hard, which is telecommunications, pharma, medical products, and public services, and the consumer goods industry, of course, and retail groceries. So those sectors, that last part of the industries, they might most likely will recover faster. And those industries, they might focus on what their business will look like in the future. And we think that at that point, there might be a wave of M&A or orders. At least we're expecting that's what people are expecting. Of course, some changes are here to stay and may affect certain sectors, because there's a high impact of the contact-free economy and digitalization. We had to become a digitalized society, and if you ever have traveled to Spain, you know that it is not very normal here in Spain to pay by credit card wherever you go. This has changed now. So there's some industries that have completely changed, and there's more pressure on just-in-time zero stock approaches. And so some industries, of course, will benefit from this crisis. But let me give you a little overview of some of those differences I was speaking about at the beginning. Of course, distribution channels are the same as for you guys in the US. Once your client decides to go to Spain, you might have direct sales or sales through representatives, or most likely through distributor agreements, or at some point your client might decide to form a subsidiary, a branch office. At the beginning, if you just use distribution channels and your client wants to sign distributor agreements, you must be careful, because commercial agency law is very different from what you have in mind when you talk about it. In Europe, it can be fairly strict and onerous, and there's a high chance that your distributor could be considered actually an agent here in Spain. This is a European-wide regulation, so it could be that once you have to terminate your relationship, they could come and ask for indemnities, or it could just be classified as a labor contract. So you want to be careful before your client signs those contracts. Another slide, and that's a slide I actually left. I usually have it in my presentation when I talk to a Spanish audience about going to the US, because you need a good contract in the US. And but I still decided to leave it in here, because I see that our Spanish clients, they usually just start doing business and don't sign a contract. Yet you still need them, and it's still good to have them for clarity, of course, prevention of conflicts, enforcement. But talking about signing a contract, you should also know that here in Spain, we're not used to digital signature yet. And this is even within the firm, we've talked a lot about DocuSign, which I know our colleagues from Harris can use. And DocuSign, we don't. It's just not recognized in most courts. So there's no way you can use that. You just need your contract in signed and writing and a copy. And you want to have it in one valid language so that there's no conflict between the languages. And you want to have your choice of law and venue. And attorney's fees is different, very different from the US. If you don't have that in the contract, then the prevailing party will still get the attorney's fees. That is a rule here in litigation. It's by law. Whoever prevails will not have to pay attorney's fees. So it's not as important as it is in the US. Once your client decides to, in other words, once your client has an office in Spain or some location, some address, a warehouse, or rents an office, or once your client hires an employee, then it's most likely considered having a permanent establishment from a tax perspective, and at that point it makes sense to actually form a company. Form a company means the most common types here are the limited liability company and the joint stock company, so the Sociedad Limitada and Sociedad Anónima. And at that point, you will see what I'm talking about, and there are differences in the practice. You'll find incredible formalism and bureaucracy, and it's not possible, as it is in the US, to form a company overnight and online. It's the other way around. It will take you time. So cost and time factors very important to keep in mind once you decide to form a company. You need a minimum capital here in Spain, which is for the limited companies only 3,000, but that also means you need a bank account. So it's not a huge amount of money you'll need. It's 60,000 for the joint stock company, but you need a bank account, and that's I'll get into more detail later. The banking has been very difficult in Spain, but I think it's also becoming very difficult in the US as well. Also, you will need tax IDs for all your directors, and that lately has turned out to be just, it's becoming a nightmare, because at the end, the administration is requesting to see the person behind the company, and it might make your client might have to travel to Spain, or at least need someone on the ground, and you will need countless notarized and apostille stamped documents, extracts, powers of attorney. So I'm saying all of that not to frighten you. You can still form a company, and we've been doing that as our daily business, but when our US clients come, usually surprised, to say the least, and because forming a company and getting tax IDs for everybody will take up to 4 weeks, and double that if you need to hire employees. So, and there's another added difficulty now. We have new regulations for foreign direct investments. That's the last part of our presentation. There has been changes in Spanish law. You might need the prior authorization for your investment in Spain. And speaking of forming a company and the banking, there is very strict anti-money laundering rules here in Spain, well, in all Europe, because this is based on the European directive. And be prepared for full disclosure, and not only for the banks, but for everybody involved. And I will explain much more about that later in the presentation. But I want to explain very quickly the two main types of EU law. European law is primary or secondary, and basically we decide, and this is something I want to explain to you, because you might not know, we have regulations and directives on EU level. Of course, everything is based on the treaties, the European treaties, so those are the binding agreements between the European member states, and those set the objectives, the EU institutions and decision-making policies. And then we have the regulations and the directives, and the regulations apply directly and automatically to all EU countries, and the directives require each EU country to achieve a certain result, but leave them free to choose how to do so. That means the European countries must adopt measures. And that's where the anti-money laundering laws come from. We have several directives, and we here in Spain, we implemented that into the law 10 of 2020 of the prevention of anti-money laundering and financing of terrorism. And one of the essential principles of Spanish corporate law is the concept of anonymity. No one needs to know who's the owner of the company. That's getting increasingly undermined. So you basically have to reveal the ultimate beneficial owner to all advisors and to all banks involved. So even we as attorneys, we need to get that information and keep it on file. And there's even there's a new directive that is going to be transformed into Spanish law, and there's a draft bill to implement that last directive for next year. Then again, another part of law that is very different from what you know in the US, that is employment law. And you might know that we don't have at-will contracts, so the hire and fire thing, that doesn't go through here in Spain. Compared to the US, the Spanish employment law is quite complex and very employee protective. But then within European, on a European comparison level, the applicable labor law is still attractive for entrepreneurs, and we have very low labor costs. So that's why we still have consider Spain as a business opportunity, a land of opportunities. The employment contract usually is presumed to be indefinite. It's another important point. So there's only limited numbers of fixed-term employment, and I think in the US it's the other way around. It's indefinite. It's not indefinite, it's fixed term. Then you have the workers' statute and the applicable collective bargaining agreements. Those define the employment conditions, so you must know those. And also for your investor that buys a business on a company, you need to be very careful if there's employees involved. That might be considered the transfer of a business as a going concern. So that means it's an automatic transfer of all employment contracts, so also joint liability for all employment law obligations. And this is Social Security, immigration, occupational hazard prevention, etc., etc. There's the termination of your employment contract is possible, of course, but there must be a severance package, not just on a voluntary basis, but it's the law. And another point I wanted to tell you, for the expat employment, there is the Social Security agreement. There's a Social Security treaty between the US and Spain. So we've worked that as well. Your employee that gets sent from the US to Spain doesn't have to pay twice or won't lose benefits. So that's very important also to know. And now in COVID-19, we have ERTES. This is a new thing. It's a temporary redundancy. So that's new regulation we all had to learn, and you might be confronted with, or your clients. That's basically it. There's IP, which you need to be aware of. Spain follows the first to register, not the first to use rule. That's quite different. So you want to register your IP, you might otherwise lose it, your brand, your trademark, and also the GDPR, how to avoid data breach notifications. Of course, everybody has heard of that by now, but Consuelo will talk more about it. And then there's several state of alarm legislation we had this spring, so extended deadlines, virtual meetings are possible now, and more virtual filings. So as I said, we are getting closer to digitalization, but we're still light years away from what you and the US are used to. And that is it for the first part, the overview of new and old legal issues. And I would like to hand over now to Andrés, who will talk about distribution channels. Thank you.
Good evening to everybody. I'm Andrés Monereo, founding partner of Monereo Meyer. As you may notice, I'm specializing in corporate and commercial law. And I would like to talk on my speech about the distribution channels. Basically, the question is how to sell products in Spain. And the starting point is two basic possibilities with a client owner structure. Nadja told you about to incorporate a subsidiary. You maybe or your client maybe decide to hire workers or to invest in other fixed cost. And here I would like to add a couple of tips regarding workers. I will come about this at the end of my speech. The cost of the social security for the company is 33% of the salary. And the severance is 33 days of salary per year. So take this in mind, and then you will see how this may be an issue talking about distribution channels. Well, the second alternative would be to sell through third parties structures. And here we found, as Nadja said, two different kind of channels, the agents and the distributors. The difference between both are very simple. Commercial agent is an intermediary on behalf of our clients and receive a remuneration as payment. Whereas the distributor acquires the products from the producer, from our clients, from the owner of the business, and sell those products to third parties. Well, of course, he obtained a profit margin, and normally the distributor has a more complex structure. He's got warehouses, he has or hire workers, a much more complete organization. Well, this is the reason, or this difference is the reason that explain that now there are two different legal bases. One is the Spanish agency contract law, which derives from a European directive, and this is a very specific and concrete law that the origin or the reason for this regulation is that while the philosophy is the agent is the weak party regarding the distribution channels, and it needs protection. You will see how this protection works. And regarding distribution, there are not a specific law. The regulation that affect distribution agents, distributor contracts are many different regulation from the civil code or the commerce code. Basically, those who apply to the purchase contracts. Let's see a little bit about how to draft the contracts or the different issues that may involve the drafting of the contract. The form, precisely, it is not a requisite, neither in the agency contracts nor in the distribution contract. There is freedom of form, but regarding agency, if some conditions, specific conditions contemplated in the law are to be agreed, those must be written down in the contract. Otherwise, it won't be valid. For example, assumption of the economic risk by the agent. This is something that we will see later on. And or post-contractual non-compete provisions. Okay. Also, exclusive rights do not need to be agreed upon writing, but it is necessary to verify, to demonstrate that they have been granted to the agent. For the distributor, as you will see in all those different approaches, there is a freedom, complete freedom of form. Okay. Well, regarding terms, it could be fixed term or indefinite contract. If no term has been agreed, the contract is considered to be an indefinite contract, which is not non-ending contract. It has no, let's say, any kind of period. It is simply a non-definite contract. The fixed-term contracts end with the expiration of the contractual period. And regarding distribution, there are no regulation. I mean, it's free. You can either have a non-definite contract or a fixed-term contract. Regarding jurisdiction clauses, although the Spanish law establishes that as a protection, the competent court will be the ones of the agent address, for the cross-border contracts, it is possible to choose validly either the agent or the owner of the producer courts of the respective domicile. It is also possible to include arbitration clauses. Regarding distribution, as I told you, there are no limitations. You can choose the jurisdiction that the parties may decide. Regarding law, although there is a freedom of choice, the regulation, most of the regulation of the Spanish agency law are mandatory. So unless those provisions establish the possibility to choose other stipulations, most of the regulation should be according to the Spanish law. Regarding distributor, freedom. Post-contractual or non-compete clauses are possible. The maximum term are 2 years. For contracts with a term under 2 years, the maximum is 1 year. And as I told you, those specific clauses should be agreed upon in writing. Regarding distributor, as always, it is possible to establish with any kind of duration and with complete freedom of regulation. The remuneration of the agent, as I told you, the agent does not acquire, it receives a remuneration, and this remuneration could be a fixed amount or a commission. A commission is understood as any kind of variable payment, for example, based on the volume of the sales or in any kind of goals that the parties agree. All transactions carried out are subject to commission when the agent intermediate with a new customers, of course, or with a customer procured by the agent in the past, or in case of exclusive rights, for example, if there is a territory exclusivity for the agent when there is a transaction with any kind of client of this territory. The remuneration the commission arises when the transaction was concluded, when the contract is executed or should have been concluded. Here, the payment of the commission, normally it is not dependent on the payment of the price, unless there is a specific provision. Is what I refer at the beginning, the risk of the agent. If it could be stipulated in writing that the commission is only received by the agent if there is a effective transfer of the money to the producer. And now we are going to talk about two typical COVID clauses, not only for those contracts, but for most of the contracts right now. The COVID clauses could be approached through the force majeure. I think you got the same institution in the States, according with our civil code. When there is an unavoidable, extraordinary, and independent of the party's will circumstance, the party who has not fulfilled its obligation due to that circumstance, it is not liable for the unfulfillment of the contractual obligation. Those obligations may consist on doing or giving, not on paying. I mean, the force majeure does not release the debtor of their economic debts, only affect to giving or doing obligations. On my opinion, the first wave of our pandemic on March and April of this year could be considered as a force majeure event. So, well, it is now being discussed in many litigations, but well, most of us think that it could be considered as unavoidable and extraordinary and independent of the party's will circumstance. Let's see what happened with the second wave of the pandemic that maybe is starting right now or since the last week in Spain. I don't know if it will be if it could be considered extraordinary or non-avoidable because, well, there were the provision of this second wave at the beginning of the pandemic. It was told, it was a scientific opinion that there will be some different waves. But in any case, I will recommend to regulate the contractual consequences of the pandemic and not to lead the discussion to court. This is, I would say, a must. And of course, all the contracts right now, most of them have this regulation. The second COVID clause, or the second COVID point, it is this phrase, rebus sic stantibus, which is a Latin phrase which could be translated like something like things thus standing. This is quite interesting. I'm not sure if in the state you got this kind of doctrine. This is a legal doctrine created by several rulings of our Supreme Court. This is a case law, but very strange because not usually the courts create regulation. We got this codification system, which is opposed to your case law system. Well, this implies, or this legal doctrine implies that the stipulation of the contract can be modified in the event of substantial alteration to the condition and circumstances under which they were first agreed upon. I mean, it implies a modification of the obligation initially assumed by the parties. It is a mechanism that changes the terms and conditions of the contract, or may change. This is a very specific doctrine that it's only applied in a very specific cases. Basically, it must be the following requisite. The first one is the extraordinary alteration that has happened. This alteration requires a profound modification on the basis of which the business operates and depends on. For example, for the last financial crisis, there were some court rulings which did not admit that this hard financial crisis was an extraordinary alteration, because the courts considered that at the end, the economy goes ups and down, and it was not so extraordinary. Let's see what happened with the pandemic, because as far as I know, there are no court rulings today. There must be a lot of litigation, and we will see in the next months or years about this. Another requisite is that as a consequence of this alteration, there are an exorbitant disproportion of any calculation between the agreed provision. I mean, what happens is that there is an imbalance that occur due to these circumstances, and this is something that must be rebalanced or adapted with the mechanism of, for example, reduce a price, or reduce a lease rent, or change certain periods, whatever is the mechanism, in order to make the contract obligations more balanced. Well, again, it is better to regulate all these possibilities. It is better to say that the pandemic wave it is avoided as a extraordinary circumstance, or on the contrary, regulate what happened. For example, if the legal measures from the government closing, as happened in the past in Spain, the commercial activity for certain days, will constitute or will suppose the basis in order to apply the rebus sic instantibus clause. Well, now let's see the terminating contracts. Termination could be ordinary, let's say normal, by mutual consent, or due to expiration in case of fixed-term contracts, case of death of the agent if he's an individual. This ordinary termination, when there is no a certain period, when it's an indefinite contract, must be in writing with a notice period, 1 month per year of contracts, with a maximum of 6 months. Always talking about agency, because in the distribution as I told you, it is free to stipulate the terms. And then there are the extraordinary termination for violation of legal or contractual obligation, or initiation of insolvency proceedings against any of the parties, the agent or the producer. In those cases, the form must be writing, must clearly express the reason for termination. And in this case, also the distributor has freedom in order to stipulate the terminating conditions. What happened in the agency when there is when the contract has finalized, but there are certain facts that make possible the right to the commission. For example, transactions that are concluded within 3 months following the end of the contract, or when the request, when the order from the client is being received by the agent or the producer prior the end of the contract. In these two circumstances, the agent has a right to get the commission. And now this is very specific, and you will probably notice that it's a very suppressive question. This is the indemnity that the agent may be entitled to get based on the goodwill. When the agent has increased the sales, or has get clients, new clients for the agent, and when those circumstances suppose a substantial benefits for the producer, for the other party, after the end of the contract. I mean, for example, if this goodwill during the following years after termination of the contract produces operations, commercial benefits for the producer, the agent is entitled to this indemnity. And this is something that the court rulings have applied also by analogy to the distributor. The distributor now can claim, if those requisites are met, also this indemnity. How you calculate this in indemnity? There is not a specific calculation formula. There is a maximum amount, which is an annual remuneration. This remuneration should be calculated based on the average remuneration of the last 5 contract years, or less if the duration of the contract is less than 5 years. So could be a very important amount, one annual remuneration. No? The calculation, this is the maximum. For the agent, you have to take the commission or the fixed remuneration you have to consider in order to calculate the maximum. But for the distributor, the basis of the calculation is the net margin of the distributor. That leads you to very interesting discussion in order to determine what is this margin. In those litigation, the financial statements of the distributor has to be carefully analyzed in order to get the margin. Well, this was the indemnity, and now the compensation for damages. Here, there are two different compensation. One is the general one, the general rule. If there is a unlawful termination of the agency contract, for example, not keep the previous notice, or for unfulfill the obligation of the contract, there will be the general damages for unfulfillment. But then there is a specific one, which is for the agent. Very rarely the distributor may ask for this, which is the right to compensation for the investment made following the structure of the producer, if such investment has not been amortized. For example, imagine an agent who received instructions from the producer in order to buy certain installations or certain machinery or whatever in order to keep, for example, the products in frozen or whatever. Well, if those investments are not amortized at the end of the contract, the agent may ask for this compensation. In some cases, the compensation and the indemnity may be avoided, may be excluded. For example, if the agent has violated the contract, that's logical. If the agent terminates the contract, or if the agent assigns its right to a third party with the consent of the principal. Here, those cases, those facts are also apply by analogy to the distributor. Statute of limitation on claims. Well, the Commission claims 3 years, and the claims to indemnity and compensation 1 year. Here, all those statute of limitation may be interrupted and started to count again if there is a requirement from the other side. For the distributor, it applies a statute of limitation of 5 years. And now, let me talk a little bit about this question that Nadja introduced to the audience regarding the label classification of the agent. This is something that happens more and more in the market. What is this risk? Well, it is basically the change of the condition of the agent as a self-employee, as a freelance person, and come into a employee. Sorry. And when can this risk arise? Well, there are two requisites, or two main requisites. The first one is what is called the subordination. The subordination means that the agent is a part of the disciplinary circle of the producer, of the entrepreneur, of the owner of the business. When this happens, well, there are many or some indications about subordination. For example, when there is a submission of working time, when the agent is integrated into the operational structure of the employer, when the control and monitoring of the quality of the work performed by the company for the purpose of possible complaints for customer and evaluated of the employee's action. The payment of the employee expenses. For example, if the employer or entrepreneur, the owner of the business, pay the internet, the handy, the computer of the agent, all these kind of expenses. This is one of the requisites. The second one is what is called to work on another behalf. This is well, the indication of this requisite is that, for example, if the employer provides the employee with all the needed working tools, as I told you before, for rendering the work performance, or when the entrepreneur, the producer, who make the decision regarding the market relations, or to decide the selection of the final clients of the agents. For example, if there is a regular remuneration for the work, the payments every month are the same to the agents. All these are indication of that the agent works on behalf of the producer. And what are the consequences of this? Well, very severe, very severe. From the labor perspective, the agent will be considered as a permanent employee. If this employee is dismissed, you will have to pay, or the producer will have to pay the severance compensation. Remember, these 30 days of salary per year. Then, of course, the unpaid contribution to the Social Security are claimed by the Social Security. And those are the last 4 years, which is the statute of limitation of this kind of claim from the Social Security. Also, there will be a fine and other kind of severe consequences. For example, the liability if there is a work accident of the agent. And the liability here for the employee will amount a huge amount of money. From the tax perspective, also the same that with the Social Security perspective, the employee or the employer has to make tax withholding every month to the employee in the payrolls. And according to the category of the employee, the employer has to deduct 15, 20, 22, 28% of the salary and paid to the tax administration. Because there were no tax withholding in the last 4 years, which is also the statute of limitation of the tax administration, the employer will have to pay these tax withholdings also with a fine, the corresponding fine. Well, thank you very much. Now I think it's time again for Nadia in order to talk about other issues.
Sorry. Yes. Okay. Thank you, Andrés. Very interesting. So this is now our third part of this presentation. This is, as I announced previously, we're going to talk about regulations and restrictions, new restrictions for foreign direct investments in Spain, which is basically when you want to form a company, want to invest, bring the cash, the money, the funds to Spain, what you have to keep in mind. And it is, again, the agenda now. I will briefly mention the new restrictions we have applied here in Spain, and then Consuelo will talk about IP laws you need to be aware of, and GDPR, of course, big issue still, and then at the end. I want to talk about anti-money laundering rules and banking briefly. So there is the new FDI restrictions in Spain, and this is what we had before pre-COVID-19. We pretty much had a very liberal framework, legal framework here since 2003. There is Law 19/2003, which basically just gave us a lot of freedom. The FDI was only affected, or better said, the government had possibility to restrict FDI that affected public administration, national security, and security and public order and health. But any other FDI, most investments, at least what we see on a daily basis, that's just an exposed notification was required for statistical purposes. Then health crisis hit, and COVID-19 happened, and there was an amendment to that law and that big liberal framework. We had the Royal Decree 8 of 2020 and 11 of 2020, both in March 2020, right in the middle of our lockdown. And the first one modified previously applicable investment laws, suspending the liberal regime for certain investments, and pretty much made these investments subject to prior authorization. They changed Article 7 of the Law 19, and according to the recitals of the new law, the economic crisis triggered by the health crisis poses a threat to Spanish companies, of course, to certain industries which find themselves exposed to takeover attempts, and hence the control is needed, is required. And then the Royal Decree 11 further detailed and broadened these regulations by introducing more definitions. So there's an exemption in place for investment under 1 million euros. You don't need any control, and but any other certain other investments beyond that amount might need prior authorization, mandatory, which means that might affect your whole transaction. It isn't as easy anymore as it used to be. We would just go to the notary, sign all deeds and documents, and then make report it to the administration. Now you have to count on more time. Your whole transaction might take longer because it might take up to 6 months to get the authorization granted if you need one. And since this is fairly recent, or we don't even know, it's not clear yet. It's not, of course not. There's no case law and there's no rulings, no court rulings yet about how these laws, these new regulations will be interpreted. And so the Spanish law basically says we need to define the foreign direct investment. Of course, there's a subjective condition for the foreign investor, and then the objective condition for the transaction that results in controlling influence. It's the two criteria review. So if the transaction results in more than 10% of political or capital control, then this is a foreign direct investment according to the new Spanish laws. And the foreign investor is defined according to the residency. So any natural legal person resident in countries outside the European Union, or a legal person resident within the EU, but whose beneficial owners outside of the EU, will be considered a foreign investor. Which is interesting because there's no working around those regulations by just forming a company somewhere in the EU. As long as the ultimate beneficial owner is outside of the European Union, then it's a foreign direct investment. And it needs to be a qualified investment, and then it needs to go into certain sectors, of course. Those are the sectors, sorry. And I forgot, I should have pasted those on the slides because it's very interesting. not all foreign direct investments in Spain require authorization. It's only if they go into critical infrastructure, including energy, transport, water, health, communications, media, data processing, financial infrastructure, as well as buildings and real estate related to those sectors, and foreign direct investment that goes into critical technologies such as aerospace, defense, energy storage, nuclear. That's already rare industries. That's not the common type of clients we will have. But then there's essential resources also, but there's particular energy and food industry, and that's something we see more often. And the last sector, the last industry, is sectors with access to sensitive information, especially personal data. And since GDPR, every entrepreneur knows that most businesses have to deal with personal data. So this will be can be interpreted really extensive and really broad in a very broad sense. That's why I said interpretative issues might come up, because we will have to see how that new regulations will be read by the administration. And another question that is unclear to us is how the so-called greenfield investment is considered, which means the greenfield investment is foreign investment by creating just a new company, which we think is not to be considered needed necessary for that we require an authorization, because it's not really competing, it's not taking over business or industries in Spain. So it should be considered differently, but we don't know yet, and we'll have to see how this will be applied in the end, at the end of the day. And then there's certain investors, of course, investors that will need to be controlled. They will need authorization if it's by the government, by foreign governments, controlled by third governments, third countries, or if it's a legal activity. Those will need prior authorization, of course. All this also has been issued, so this new statutes in Spain, this new regulations is based or has been has come up based or because of a EU regulation, which is the so-called FDI screening regulation, and that has been in place. That came into force in April 2019 already. And to be honest, I wasn't aware of that until this year, until we saw the changes in Spain. But those Spanish reason regulations, of course, they are based on the European regulation, and in the Spanish laws pretty much apply what the EU regulation was giving the framework for the member states to be applied. So the FDI screening regulations on the European level is not, as I explained before, it's applicable directly, but it only gives a framework, and the countries don't have to participate. It's more a recommendation to get a common framework for screening mechanism, and that regulation gives a list of factors potentially affecting the security or public order in the EU, and it also introduces a cooperation mechanism between the member states. And it will come into force on October 11, but then there's some retroactivity. So it means that even regulated transactions that have been concluded by now could be screened retroactively, which is very interesting, and we'll have to see how that turns out in practice. And basically, it's the list of factors potentially affecting security or public order. Two types of factors. It's either based on the sector. It's certain sectors, as they're listed here. It's a long list of sectors. This is just a part of it. So it's easier to look for the sectors that are not included than the ones that are included in this regulation. And or on the type of investor, the background of the investor. And again, that has been implemented in Spain now. This is either an investor controlled by a third country or somehow involved in illegal criminal activities. And so, as I said, Spain's new regulations pretty much apply these factors. And then again, yeah, there's a screening mechanism. There's a list being published by the Commission. There will be annual reporting by the Commission, the European Commission. Member states must notify the Commission if an FDI is screened in their state, and other member states might provide comments to that screening, or the Commission may issue opinions. And if an FDI is likely to affect union interests, the Commission may issue a screening or start a screening with the responsible member state must account of. So it's going to be very interesting, and it's not to scare anybody away, but certainly to not forget about if you have an investor looking into Europe, and this will be the same for other member states as well. And then in the middle of the pandemic, the COVID-19 crisis, of course, there was the European Commission issued a communication calling the member states to make full use of the existing screening mechanisms already based on the regulation I just explained. That was this part of the presentation, and I will give over to Consuelo now, talking about UIP.
Hello, good afternoon. I am Consuelo Álvarez. I am based in the Barcelona office of Monereo Meyer Abogados, and I'm specialized in intellectual property and personal data protection. Today I'm going to talk about how to protect your industrial property in Spain and its situation during the pandemic, and also about the GDPR, the General Data Protection Regulation, data breaches, and the most frequent questions we have received during the pandemic. So the Spanish Patent and Trademark Office is the public institution responsible for the registration and granting of the different types of industrial property in the territory of Spain. The registrations that you can make in the SPTO are trademarks and trade names, industrial inventions such as patents and utility model, industrial design, and topographies of semiconductor products. This is the main legislation applicable for the regulation of this right, which include the law on invention patents, law on trademark, law on the legal protection of industrial design, and law on the legal protection of the topographies of semiconductor products. Of course, the protection of Spain of some of these rights can also be achieved by the registration within supranational offices, such as the European Union Intellectual Property Office or the World Intellectual Property Office. However, on this presentation, we are going to focus on the protection of at a national level, and in particular on what has been the situation during the pandemic. The Royal Decree declaring state of alarm for the management of the crisis situation caused by COVID-19 interrupted all of the administrative deadlines. This included, of course, all of the procedures within the SPTO, and the procedures were resumed on June, the 1st of June. Of course, this didn't mean that the parties could not carry on with the procedures. It was possible to apply for trademarks or designs or other titles. It was also possible to file oppositions or to answer to oppositions, but only there was an interruption of deadlines. This means that the SPTO did not have an overload of work after the 1st of June, and well, the work still carried on. Also, during this period of time, the office continued to develop actions to guarantee the improvement of the electronic services, so that the interested parties that had a ongoing procedure on the SPTO did not see damage their procedure. Also, in this sense, the WIPO established a new online service of the Madrid system to facilitate the filing of international trademark applications. We have also noted that there has been an increase of resolution of disputes on technology and intellectual and industrial property during the COVID-19 pandemic, with the mediation of the WIPO Arbitration and Mediation Center, or by means of other dispute resolution, alternative dispute resolution procedures. I also wanted to show these graphics so that you could see how it has how the pandemic has influenced the number of applications that there has been within the SPTO. As you can see, the influence has not been so negative. More or less, these graphics show how the applications that there have been for the last 3 years on a monthly basis. We can see here on the yellow line the application from 2018, also the application from 2019 and from 2020 for the patents, trademarks, industrial designs, trade names, and utility models. And as you can see, well, maybe at the beginning of the year, the number of applications was lower. But on the last months, these statistics, this graphic shows that the companies have been investing on their industrial property, and they have dedicated this time to protect their intangible assets. So we see this as something promising and as something very positive for the market in Spain. So now about GDPR. Okay, in order to avoid data breaches, it's very important to understand the General Data Protection Regulation and to understand the responsibilities that a data controller and a data processor may have. There's a principle in the GDPR that establishes the privacy by design and by default. This means that every time that a company is going to initiate any activity where personal data is going to be processed, they have to think what kind of personal data is going to be processed, what kind of processing there is going to be, what kind of risks there are going to be for their personal data. In order to do this, the companies, the data controller and data processors have to make a risk assessment and an impact assessment. With these assessments, they will be able to implement and update data protection policies and procedures, which will apply security measures, which are organizational measures, and also cover technical measures. In order to avoid data breaches, it's also very important to train employees on GDPR. Constant surveillance is also very important. And when transferring the data to data processors, it's important also only to make it under a data processing agreement, and only transferring the data to data processors that provide sufficient warranties with regards to personal data protection. And of course, it is important to avoid data breaches to always maintain a data processing record, which is also an obligation for data processors and data controllers established on the GDPR. If personal data breaches are not managed properly, this will be considered properly and according to the GDPR. This will be considered a serious infringement following Article 73 of the GDPR. This could involve an administrative fine of up to 10 million euros, or in the case of an undertaking of up to 2% of the total worldwide annual turnover of the preceding financial year, whichever is higher. Also, data subjects may lodge complaints with a supervisory authority, exercise their right to an effective judicial remedy against a supervisory authority or against a controller or processor, and exercise their right to compensation and liability. One of the obligations when there is an obligation of the data controller and of the data processor when there is a data breach is to notify the Spanish Data Protection Agency. The Spanish Data Protection Agency is the Agencia Española de Protección de Datos. This notification has to be made within 72 hours from time of awareness. And but is only required if rights and freedoms of data subjects have been compromised. This notification should include a description of the data breach, a description of possible consequences, and a description of the answering measures. The answering measures should be the measures that the data controller or data processor has adopted once they have been aware of the data breach. Also, another obligation is to have a record of the breaches and notifying the data subject when there is a high risk to the personal data by the breach. So this will not always be an obligation, but when there's a high risk, yes, the data subject has to be notified.
Seems we are having some technical difficulties with Consuelo. Maybe while we wait for her to reconnect, we can start addressing some of the questions from the audience. So first of all, the first question that we have is the following. If contracts can be terminated on the basis of insolvency proceedings, what procedural or substantive safeguards exist under Spanish law to prevent parties from abusing such provisions?
Sorry, how was the question at the end? How was the prevention of?
Yeah, so basically, what protections exist under Spanish law?
Hello? Can you hear me or see me?
Yeah.
Oh, okay, I'm back. I don't know what happened. I'm sorry for that.
Okay. Well, Consuelo, we moved on to the questions section. So we'll if maybe we already started asking one question, so let's do that, and then maybe if there was something else you wanted to tell us about, we can do that.
Okay.
But, so the question is the following: if contracts can be terminated on the basis of insolvency proceedings, what kind of safeguards, procedural or substantive, exist under Spanish law to prevent parties from abusing such provisions?
I don't know if I got the exact question, but if you mean how in the agency contract affect the insolvency proceeding, it is an automatic cause of resolution of the contract. I mean, if the agent is involved in this insolvency proceeding, in this bankruptcy proceeding, the contract finalized without any kind of compensation, without any kind of obligation from the producer. I mean, I can see any kind of abuse from one of the parties if, for example, want to escape from the contract and by initiating the legal procedure. If this is what you try mention, Fred. I mean, the abuse. I can see the abuse linked with the.
Okay, yeah, I think that's what the question was getting at. We have one more question, and this has to do with the investor screening. Is this process, and this might be, I understand this might be a bit of an unfair question, but is the screening of investors similar to the screening conducted by the U.S. Treasury Department when, in the case of specially designated nationals? I think I'm going to propose an answer, and then you can tell me if that's correct. I think that the Treasury restrictions have to do with sanctions. So, for example, countries with governments that are committing human rights abuses, that sort of thing, then the U.S. Treasury Department will screen that kind of investment into the U.S. economy. I think that's a little bit different, right, than the screening you are talking about in the case of Spain, correct?
No, it's not that different. And I forgot to mention, there is an administrative part of it. If I undertake foreign direct investments without authorization, then it's considered a serious infraction. So there's penalties to it. But then there's a civil law side, the contract, and it's invalid. So there's two sides, two consequences. But it is similar to what we have here.
Okay, well, we're good then. Yes, we got our answer. Okay, well, if any of you have anything else that you'd like to add before we sign up, this is your chance. Otherwise, I would really like to thank you on behalf of the WSBA and the International Practice Section, and obviously on behalf of your colleagues at Harris Brick. And I would like to thank you for your time. This was a truly informative event, and I'm glad that we were able to transpose some of the events that we had planned for your U.S. visit to the online space. And for our audience members, there will be additional events coming up. We will keep you informed of those through our social media and other channels if you're interested in this topic. So with that, thank you all once again, Consuelo, Andrés, and Nadja. Thank you.
Thank you. It's been an honor to talk to our colleagues in Washington, and we look forward to have another opportunity to give our ideas, our contributions to the formation of what is the main topics of our legal system. Thank you.
Thanks for having us.
Thank you.